Okay, welcome everyone to the My HR Genius, Thompson Co. Cousins and Irons webinar. My name is Kevin Mosher, and I'm a partner over at Thompson Co. in the Minnesota office, and I'm a labor and employment HR. I'm supposed to say this in a specific way. I am a certified specialist in labor and employment law, certified by the MSBA. So I am really excited to present this month. We have not really had this topic before. I've been doing this webinar series for about 7 years now. I think we started initially as seminars, and then we moved to webinars in about the fall of 2012. So yeah, in the 7 years we haven't really done a topic like this. So really excited to do it, and just to talk about some just general HR issues and mixing in obviously legal and risk analysis to this. So yeah, so HR red alert, right? So this is what people doing risk analysis, risk management, and HR. It's kind of like the combination of that. And because as much as work comp is something that is thrilling and exciting, I'm not going to talk a lot about work comp strategies. I've got specific webinars on that, and I'm not talking about FMLA, leaves of absence, or anything like that. I mean, we're going to talk about policies and ways to avoid our lovely employees getting into trouble as much as possible. So I am, if you're really excited about having a work comp conversation, call me on the side or something like that. Though I do find work comp to be fairly tedious, personal opinion. Okay, so anyway, this is me. I am, like I said, partner up at Thompson Co. We have, for those of you that don't know, we have a unique, there's no other law firm in the country that does this, but we have a unique all-you-can-eat, HR hotline and other stuff and great stuff that goes along with it, but subscription-based legal service, and we offer that at Thompson Co., and you're welcome. We have a website and everything at myhrgenius.co or at the Thompson Co. website, and you can register. It's a month-to-month program. It's really, really cool. So if you're not on the program, if you have any questions or want to give it a shot, it's pretty affordable, and it is pretty awesome to be able to call HR lawyers about any HR issue and not have to worry about legal costs. So. A lot of services that come with it through Thompson Co. on from our labor and employment group, including a hotline and webinars and updates. And we do weekly updates. We also do podcasts. I've started podcasts. So for those of you who haven't listened to my podcast, you can also get that at the myhrgenius.co website. I get calls probably, I don't know, daily. People asking me like how they can listen to me talk more, and I always just say, hey, go and listen to the podcast. That's why we're doing the podcast, not because it's informative or anything, but because I just know a lot of people really like to hear me talk more, so that they have in English they call it earworm, but I think it's better in German when it's Ohrwurm. In their head as they're going to sleep, and they can't get my voice out of their minds. So anyway, today we're going to talk about, well, first of all, we're going to be very tongue-in-cheek today. And so we're going to talk about our little walking bundles of risk known as employees. And we're going to talk, we could talk endlessly about the difficulties that employees bring to the table. And for the most part, a lot of people, myself included, got into HR. Now, obviously, I'm on the compliance side and help companies with strategy, but for the most part, a lot of compliance. That's primarily what lawyers get brought in to do, like myself. And we didn't. It's not like I became a lawyer to help fire people, but that's what I pretty much help do on a daily basis. And employees are great and all, but for the most part, they just cause a lot of problems. And a lot of these problems are injuries, and they harass people, and they fall, and they swear at customers, and they crash cars, and they just do a lot of stupid stuff. But we really, at this point in our economy and civilization, we can't get rid of them and still perform our business. Now, there are some businesses, obviously, that are moving toward AI, and I think I just saw a study, it, of course, like hit the New York Times or whatever news feed just because it was, so interesting, and I'm sure, clickbaity, that whatever consulting group said that, by whatever date in the, close-ish term future, AI was going to replace like 800 million jobs. That's a lot of people, a lot of bad employees gone. I don't know what HR people would do. There probably wouldn't be an HR profession if 800 million, terrible employees were taken out of the worldwide workforce. But we might toast it for a while, but then we wouldn't have anything to do. So at the end of the day, we also, it is kind of interesting to deal with these problematic employees, although they are frustrating and add risk and liability to our companies, which requires insurance and legal fees and all that sort of thing. So we are going to talk about technology. We're going to talk WFH, work from home, and some changes, obviously, that are going on with the economy, and obviously the work from home arrangement is not new, but the technology allows for it. And so we're going to talk a little bit about that and what some of the risk might be for us, and us being our companies. And then we're going to talk about just some legal stuff with OSHA and overtime and harassment and cell phone policies and social media and just things like that, and just some strategies and things to be aware of. Also, we're going to talk a little bit about drug testing and drugs in the workplace, if only because it just continues to come up for me as a topic that is worth that employers just have so many questions about because of the continuing legalization of not only medical cannabis but recreational marijuana use. And how that's, what's that going to look like from a risk standpoint? What do we need to do? Do we all need to just start drug testing like crazy, even in white collar type of working environments? I mean, it's pretty obviously we want to do drug testing. We always have done, because it's required by law to do it for CDL, for certain CDL drivers. But for your white collar office type of job, should we be looking at drug testing? I mean, are people falling out of their chairs and getting hurt and that sort of thing? We want to talk about lowering our risk. So let's start with work from home and work from home type of arrangements. So I don't think this will come as a surprise to anybody, but work from home is something that has increased significantly. Obviously, the cloud and internet technology have allowed for that. People say, I will say this, people say that they're more productive when they work from home. I don't know if that's true or not. It's just really hard to, I know I've seen the statistics, and I'm sure there's plenty of studies out there from various workplace consulting groups talking about work from home. I'm not sure if I entirely buy it. I know too many friends of mine and people I know that just slack off like crazy when they work from home. You hear the anecdotals all the time. That being said, the office place is changing. Work from home is becoming, for certain jobs, obviously, warehouse workers are not going to be working from home all the time. But supervisors, we've got field people. We have a lot of office jobs. The cloud, the internet, it just really allows for so much ability to work from home. And especially in the cities with drive time and with recruiting in a tight economy, you're going to be looking for those jobs where you can work outside. Your people, talent recruiters are going to be looking for employees in rural areas, and not even just in the United States, but outside the United States. Especially in the tech sector, where you might be developing some software, you might be doing some customer service. I mean, that stuff is being outsourced, and it's you're often able. There are websites for this, obviously, where you can go onto the website and do project work from people from all over the world, and they're not employees; they're just contractors, they're project workers. The website facilitates it, and so it's not just work from home, but it's also work abroad and just a very atypical workforce. So, okay, the point of that is, what does that mean with the shift from your typical office arrangement to a work from home type of arrangement? Well, the issue is, what does that mean for a couple things? One, I don't know if anybody's heard, but cybersecurity is kind of an issue. Obviously, we've had some super huge data breach problems and lawsuits and liabilities and sensitive confidential information being leaked out. We have, whatever they call them, sounds like internet pirates or whatever, going around and taking over, breaching firewalls, and holding for hostage companies' data and information, and demanding basically, a ransom. That happens. It happens a lot. And now that a lot of it's always reported and everything, but it happens. And so cybersecurity, it's a big issue. We worry about, anybody working from home. It's almost certainly the person that's working from home in today's workplace is going to be hooked up to the internet, and then internet is going to go to the cloud. It's going to go, or it's going to dial in directly to your server if you're doing your IT in-house. And there's a cybersecurity concern with that, right? So that is a risk. There's a lot of, the last several years, cybersecurity and insurance policies have been out there. That's trending for taking some of that risk off the table. That's definitely a growing area for risk managers to take a look at, and a lot of that is being driven not only by the increase in piracy and all that, but also because of the work from home and making sure that all of your employees that have potentially sensitive information can access the company, that they're also protected. The other trend, the other thing that we're seeing, we'll go to the next slide. So we're going to talk about OSHA. We're going to transition to OSHA. And so from a work from home, in a work from home situation, what is your responsibility under OSHA? And it's not, I don't want to say it's not as high as it is in a workplace. So, and I talk about this all the time. Obviously there are, we'll talk about it in before the end of the hour here, but there's obviously harassment, and we have anti-harassment laws and all of that based on a protected activity. But if we just kind of step back and we think, what are some of the basic requirements that an employer needs to provide? And one of them is that an employer needs to provide a safe working environment. And obviously, there are injuries, and that's why we have work comp, and we have other, property casualty policies and all that sort of thing to take some of that risk off the table. But OSHA requires that you as an employer provide a safe working environment. So what does that look like when you've got a work from home arrangement? Because we've got these employees just doing whatever. Of course, they're not, cynical me, they're not working all that hard. They're sitting there, they're playing video games while they're talking to your customers on the phone. If they're like CSR, whatever they're doing, they're, fiddling around with, something. And what is your obligation to make sure that they're following the rules, that they're not injuring themselves, that their work from home arrangement is not going to be injurious to their body or to other people? Not that you probably have customers and stuff like that showing up at work from home arrangement employees, but you never know, could happen. So it is something we need to consider. So obviously we have safety managers and people who are really like all over this in a work office environment or at a plant or whatever, blue collar, white collar, doesn't really matter. But it's much more common for us to do that from a safety compliance perspective for the office, the typical four-corner office that we've all known and loved over the history of workplace. So what is the responsibility? So you need to ensure, even in a work-from-home situation, you need to ensure that the employee has a safe and healthy workplace. You don't have to make the entire house safe. So you don't have to, now could you send over a safety consultant to take a look at the house? Yes. Could you also, this is probably easier, it's probably cheaper, could you also have your safety consultant, safety director, whatever, put together a bullet point list of what is required from a work from home relationship, and then affirmations from an employee saying, yes, I do have a chair. Yes, I do have a desk that is as ergonomically good for me as possible. Yes, I affirm that my desk is not, sitting on a fault that is going to fall into a cavern or something like that. All of these, you can have a bunch of affirmations and have the employee sign off on it as a condition for working from home. That will give you at least an affirmative showing in the event that the employee is injured in the future and then starts to claim that you violated OSHA. Obviously, work comp is a little bit different because work, depending on the state, but work comp is probably going to cover any injuries. But if there's an OSHA issue or some other negligence type of issue, we can point to this affirmation that the employee has affirmed that they have a safe working environment, that they know that they can contact the company if they need anything. All of these things, we want to get the employee to sign off on it. This is good legal type of documentation to have from employees as a condition of them working from home. Is it going to be, fancy legal word, dispositive? Is it going to be, the type of document where you're just like, boom, there it is, walk away, hands up in the air, and, you're all done with dealing with their attorney or, whatever, the insurance companies, if insurance companies gets involved? No, it's not going to be like your end-all legal document that you just, slam down on the table and you just say, see that later, we're done here. No. But is it going to be better than nothing? Absolutely. What would be even better on top of it is if you were to send somebody like a safety consultant or something like that to the employee's home, but it's also pretty expensive, and you're probably not going to do it. A lot of these employees are pretty remote, and you might never really go and see them. Really just kind of depends on what type of how much money you want to spend. You want to spend on addressing this issue. But the point is, you don't need to make sure their whole house is safe and meets like all these OSHA standards. You just need to make sure that they know that, and they affirm that they have a safe working environment. We don't have ergonomic standards. Hang on, next slide. Ergonomics. We don't have ergonomic standards because Bush President 1 vetoed it, and otherwise, I can't imagine how many webinars I would have done in the last 7 years about ergonomic rules and all of that. Just makes me excited thinking about how much I could have talked about if those ergonomic rules hadn't been vetoed. But anyway, we don't have them, but we still, just because I don't want to say slightly care about our employees, because for the most part we probably don't. Again, tongue in cheek here today, but what we don't like from our employees is work comp claims. And we don't like lost productivity if they're a good employee. We don't like lost productivity from them because they're injured or, because of their workplace and because their chair is bad or something like that. Because for the most part, we invest in employees, especially, it doesn't matter what type of, all employees, there's some level of investment. Some employees are even more expensive when you're going through talent recruiting for them. So obviously there's some percentage that every business assigns to costs of hiring an employee and training an employee. And even if there are no ergonomic rules, for the most part, we don't want them to get hurt, and we want them to sit in their desks all day long, right? I will gladly buy a really nice cozy chair for a lawyer that's going to sit for 14 hours in the office. Like, there you go. It's a good investment for them. And So we want to do that. So ergonomics, we want to consider it. So a lot of companies, obviously yours might be one, if you've got a work from home arrangement, you might set aside a budget. You might ensure that they've got a chair. You don't have to. You just have to make sure it's not a broken down clunky chair that's going to hurt them to meet OSHA standards, but it might be a worthwhile investment to make sure that they have an ergonomic desk, to make sure, or at least a decent enough desk, to make sure that they, obviously you're going to have the cybersecurity, the Wi-Fi and all that, the firewall taken care of. You're going to have all that taken care of, but also just their work, their desk, their chair. You might want to put together a checklist. And again, you don't have to send out your safety director to do this. You could put this checklist together alongside, as maybe as part of the affirmation list that goes to the employee that says, look, hey, as a condition, here it is. I'm signing off on that I meet all of these things, and yes, I have a great chair, and yes, my desk is fine, and all these sorts of things. It will give you an affirmation that if the Department of Labor comes calling and says you don't meet OSHA standards, that, yeah, but here the employee signed off that we did meet all these things. I don't know what they're talking about. Now, that isn't very nice that they're now going back on their word. Shame on them. They shouldn't be doing that. So as HR people, as insurance people, we are all very accustomed to understanding workplace injuries. Obviously, you're going to need to know what the work comp laws are of your state and what the reporting laws are. But for the most part, if an injury is significant enough beyond like a bruise or a Band-Aid, something like that, we're probably going to do some sort of first report of injury, whether the state requires it and or whether the insurance company requires it. We're going to want to make sure that we take care of the protocol and that we report it. Same goes for work from home relationships. Same goes for employees that get hurt in the field. It just makes it harder sometimes to do the investigation. If it's a work from home relationship, you might have the employee. I mean, I don't want employees to assume the employee would be devious, but you might have an employee lie about how they hurt themselves. I know it never happens, but let's just pretend that there's maybe, we've got 25 million people in the United States. Maybe there's one or two of them out there that might fake or lie about a workplace injury. Okay, let's just hypothetically assume there's somebody out there. If that's the case, either way, you're going to want to ascertain that. You're going to want to investigate that. You're going to want to determine. It's harder to determine if the person's working from home. Again, we probably don't see a lot of work from home injuries because so many of those are white collar type of, sit at a desk type of jobs, but the risk is still out there. And if the employee reports it, and it's going to come down on you, you're probably going to you might report it to the carrier. The carrier is going to assign somebody. The adjuster is going to investigate it. Maybe you as a company are going to investigate it, and you're going to have to. Work from home is really no different in that regard. Regarding the duties and injuries that occur. Here are some examples of what would be work related and what might not be work related. Again, difficult to understand sometimes, especially if the employee is like that one employee in the United States that misrepresents the nature of their injury. So again, I know these are crazy hypothetical examples, but just bear with me on them. Okay, that's work from home. Let's talk about cell phones. I've noticed people have cell phones. I've noticed people also use their cell phones when they are in the car. I personally am having a really hard time with the new Minnesota law that says you've got to be hands-free. I know my car has Bluetooth. I don't really know how to set it up, or I just haven't spent the 10 minutes that does it. So it's the hands-free thing is annoying to me. Okay, let's look at, there are a number of states, Minnesota included, but there are a number of states that have hands-free laws. Are those, we're going to use the word dispositive again, are those laws going to be dispositive to the, in the event of an injury, such that you as a company can shift that risk back to the employee? So, for example, employee in a state, on their phone, violating the the entirety of the state's hands-free law, and obviously in violation. Speeding at the same time, going 55 and 35, I don't know, something like that. Speeding, violating 2 laws, probably violating some other law about not, about being distracted. Okay, they get in an accident. How's that going to play out? More likely than not, it gives you some argument but more likely than not, they're going to be covered by work comp. They are, and likely under various responded superior doctrines, you're very likely to still be picking up the claim of anybody else that's injured that's not working for you. So it's not going to be in and of itself, if you have a policy and maybe you even do training and you say, get off the phone, and you put in your handbook, which I totally recommend, that you have a hands-free policy. I don't care what your states say. You should have a policy that says no being on phones, no texting while driving, no being distracted while driving. There's no bad that can come from that if you have that sort of policy. It gives you the opportunity to try to shift that risk over to the employee. Is it going to work? Probably not. But it gives you the chance, and it gives you the argument, and hey, you might find a court in the United States that says that that's good enough, that shifts the burden back onto the employee, and maybe you can avoid some of the risk from an accident or injury. But I still think, because we're trying to parent our employees to an extent, I still think that it's really good for companies, because we don't want our employees to get in accidents. We don't want claims on our various work comp or property coverage or casualty coverage. We don't want these sorts of claims against our auto policy. We don't want these claims. So it's good to have training. It's good to have a hands-free policy. It should be communicated to employees that the expectation is that you are hands-free. You're not distracted while driving. Also, it gives us an absolute ability to fire that employee, and we have a really good chance at winning at unemployment. You never know with unemployment. Obviously, it depends on a million different factors, but should you win? Yeah. Doesn't mean you're going to win, but if the employee willingly, knowingly violates a policy like hands-free or distracted driving, you have a very good chance of winning unemployment. So know the state you're in, know whether you have a hands-free law, but even if you're in a state that doesn't have a hands-free law, it's really, really a good risk management policy to put it in your handbook or some sort of other policy, place, communication, however you want to communicate to employees. Doesn't matter to me. I threw some drug testing stuff in here, and we talked about drug testing a couple months ago. Yes, before there was snow on the ground. And so we talked about drug testing, and so I wanted to talk about it a little bit because I just continue to get so many calls about marijuana and drug testing and all of that. And so anyway, a lot of states, just a little bit of a recap on the September webinar. And by the way, if you want to watch the September webinar, it's on our myhrgenius.co website. You can watch all of our webinars. We post them on there because, again, I know people want as many opportunities as possible to hear me talk. So the primer on drug testing. So I think we have to ask ourselves, as every company has to ask themselves, why would they test? Now, if you have a policy, a company where you've got people who are working safety-sensitive jobs, I really just feel like you should be testing, unless it's to the point where you just can't even recruit anybody, because if you put a drug testing policy in place, like basically that would knock out everybody that applies for your job. And I'm not saying in that situation I wouldn't do pre-employment drug testing, but for all safety-sensitive roles, I would give yourself as a company, there's no downside to this, give yourself the opportunity to test employees post-accident, or to do randomized testing if the state allows for it, to do randomized testing on employees in safety-sensitive jobs. If people are driving a forklift, if they're driving vehicles, if they are carrying heavy packages, we really don't want them stoned. I mean, for the most part, we just really, that's not going to be conducive for following rules and for following safety protocol. There is an increased chance that that person hurts themselves or hurts others. And if a drug testing policy practice can mitigate and lessen that risk, why not do it? And so I just say, know your state, look at the state. Some states have very complicated rules regarding drug testing, mainly Iowa and Minnesota, the states with the two most complicated rules on this. A lot of states don't have anything. There's no drug testing policy. But it's going to become, as we continue to water down prohibitions on marijuana and cannabis, and like I said, in September, there is no, like, even though it might be like recreational marijuana might be legal. I think it's in 11 states. It'll be 12, I believe, when Illinois goes online with it in January. Even in a situation with recreational marijuana, there is no state that says that that an employee has a right to be impaired in the workplace. It's specifically even said, like, even if you're on a medical cannabis, where you're taking medical cannabis because of pain or whatever you've got going on, there's still prohibitions in almost all of these states that say that you that's fine. It's legal for you to have some of that in your system. The cannabis in your, having taken the cannabis, so the THC or whatever it is in your system. There's chemical words for that. But that doesn't mean that you get to be impaired. And so impairment is almost certainly not allowed. And the reason it's not allowed is because the legislature, there are at least some bright people around the country that are in the state legislatures, and they've at least recognized that, hey, even if the person's on medical cannabis, let alone recreational marijuana, that they still shouldn't be impaired, intoxicated, and at the workplace. That increases risk, increases harm, damage, all that sort of thing. I think especially in a recreational marijuana state, again, there's like 11 or almost 12 of them. I think drug testing in safety-sensitive jobs, randomized drug testing, I think it's something that should absolutely be considered. We need to find new ways, and employers are doing this, risk managers are doing this all the time. We need to find new ways to mitigate the risk of workplace injuries. So here are the reasons why, which I kind of just talked about, but why employers might want to test, might be required by law, like DOT, CDL drivers, reduce mistakes, reduce injuries. I mean, this is primarily focusing on injuries. So considerations, if you are looking at a drug testing protocol policy, doing it in place, it needs to be in writing. You should have, some states require it, so some states mandate that, look, you can't even, like in Minnesota and Iowa, you can't even do drug testing. I don't care if the person comes in super stoned and they're like, I'm really high, or whatever they want to say to you, and they have like, little like marijuana cigarette hanging out of their mouth or something like that. You can't go and test them. Like, if you don't have a written drug testing policy, you don't get to go test them. There's a law. It says specifically you cannot test them without a written drug testing policy. It is good practice. It is best practice to have a policy in place. You also want to watch out for discrimination. Obviously, we don't want to just go drug testing every person that's a minority or of a certain ethnicity that works at our facility. I mean, that's potentially discriminatory. We don't want to do that. So we want to have a framework. If we're doing this, if we're going to have a policy on this, we're going to test on it. We want to have a framework around that. We want to understand our state laws. We want to specifically list the nature, the types of tests that we're doing, whether it's post-accident. And again, I recommend post-accident testing, and as well as safety-sensitive jobs doing randomized testing. Not saying you have to do pre-employment testing. That might be a real problem for you. But I think just throwing it out there, shot across the bow to people, saying, hey, we want to understand if you were intoxicated when this injury occurred. We want to understand, like, are you just randomly coming into work intoxicated, impaired in any way? Because we don't want injuries going on. Here are the typical triggers, a list of the typical situations where employers have the ability to drug test. And again, you need to look at your state laws because some states have restrictions along these lines on testing. Policy requirements. Here are just a list of some requirements that you might want to consider. And again, some states require certain things in policies, but for most states don't. But just ideas that if you are drafting a policy, again, what are we trying to accomplish? Go back to that slide a few slides ago. Ask yourself, what are you ultimately trying to accomplish? Are you trying to be like the NFL, where you're just trying to basically weed out people who are stupid enough to fail a drug test, even though they've known about it for years at the NFL Combine coming out of college? Is that what you're trying to weed out? Or are you just trying to weed out stupid people? Or are you trying to really prevent lower risk through, randomized testing of safety-sensitive job, post-accident, that sort of thing? Let's talk about harassment. Who doesn't like to talk about harassment? So again, we're going to get back to cell phones. There's also this thing called the internet and emails. So along the lines of cell phones, emails, there's texting. I would say that, if harassment is like a product that evolves over time, or something that evolves over time, texting harassment is kind of like the new cool evolution of harassing. I mean, there's so many really, really cool ways to harass people in the workplace. I mean, back in the day, it was maybe a poster in your locker on your cubicle. Obviously, touching and groping those are always great mainstays that have always been around. Hitting on people at a happy hour, that's great. Again, since the dawn of time, I'm sure that one has been around. But cell phones and emails, Facebook, Snap or Snapchat, however you want to say it, Instagram, these are all really more novel ways of coworkers going around and harassing one another. And so it's interesting. We need to kind of keep up with all the kids are doing these days. So it's important to know the point here is that the medium of harassment doesn't matter. I mean, it matters, but it doesn't matter from a legal standpoint. Employees need to understand, and then, we're getting toward the end of the year. This is a good time to review and update your employee handbooks and your harassment policies. I normally recommend, obviously every business is close, is different, so, you don't have to listen to my advice on this. But for the most part, I recommend, first of all, you have to have an anti-harassment policy. If you don't have an anti-harassment policy, roll out an anti-harassment policy. If not December 1, January 1. You need to have it. It allows you certain legal defenses in the event of coworker harassment. It's also just kind of good for culture and all those sorts of things. Your harassment policy you might also want to prevent bullying in the workplace. I generally equate harassment and bullying in a policy, though legally they are not equated. Bullying is not the same as unlawful harassment. It's not prohibited by law. People think it might be, it's not. You also might want to throw in discrimination, right? So when we look at harassment policies, we might talk about like anti-harassment, anti-discrimination, anti-bullying policies. You need to have a reporting mechanism. It needs to be in there. That's critical for you. But the medium for harassment, for discrimination, for bullying doesn't matter. Any medium should count. It could be a string with a couple cans on the end of it, where one employee says something off color to another employee. It could be a poster in a cubicle. It could be email. More commonly, we're seeing texts. I don't know why employees think that texts aren't saved and that as if they're not going to get back to the company when they text pictures of their genitalia or they, say crazy things. Also, I don't understand why employees think that it's not harassment if it's outside working hours. That is absolutely not the case. Your harassment policy, your anti-discrimination policy, your anti-bullying policy, all of them, or all of them combined, whatever, they all apply 24 hours a day to all of your coworkers. And the reason is because ultimately harassment, whether it's, getting hit on at happy hour or something happening over a weekend, whatever it is, whether it's in the workplace or outside the workplace, it impacts the workplace itself. So it goes from outside, and then it penetrates and comes into the workplace, and then it becomes a problem. Now, obviously, from a liability standpoint, it's a little bit different, especially if there's some touching or assault going on. It's going to be a little bit different. There might not be as much, certainly there's not going to be as much risk or liability for the assault if that happens off your property, right? Might be a little, if it's like on a work event or something like that, obviously there's going to be some nuances, some circumstances to understand. But from a harassment standpoint, from an unlawful harassment standpoint, we don't care where it happens. We don't care if it happens at a convention. We don't care whether it happens at a happy hour or if it happens in the office. It's still harassment. It should still violate your policy. And employees, I don't know, they drunk text coworkers. They then lie about it and they say, that it wasn't them. They send anonymous messages on Snap. They send Facebook things, messages, instant messages. That's what I guess it's called. They send IMs to people. We need to, when we find out about this, we need to apply our harassment, our anti-bullying, our anti-discrimination policies with equal effect in all of these. We want to investigate them, right? So as HR, risk managers, we want to investigate all of these situations and to come up so that we can prevent it. We can't put the jack back in the box on anything that did occur, but what we need to do is stop it going forward. We want to mitigate our risk. We want to take it off the table, ideally going forward, so it doesn't happen again. And if you have an employee say, well, I was drunk and it was on Friday night and I wasn't working, none of that matters. Drunk, stupid employee is a walking little bundle of risk for you and might need to go, might need training, whatever. Whatever you need to do to stop that employee from causing you potential legal liability and risk, you need to do it. Training, termination. Termination is easiest because that is like an absolute way of handling risk, taking it off the table. Again, there still might be risk from what happened in the past, but going forward, the only thing we can do really is to go forward and try to mitigate or eliminate our risk as going forward in the future. So anyway, texting, no real different than old school harassment. So what do we want to do? We want to make sure that we probably want to update, if you haven't updated your harassment policy, we might want to update it so the kids these days, understand a little bit that, hey, emojis might be considered offensive. I will tell you, every time I get a text from my mother in all capital letters with 5 exclamation points, and then there's 4 random question marks. There's no question, but there's random question marks. I think she's trying to be cool. I'm not really entirely sure. I find it like I'm being yelled at like I was a 10-year-old, but that's how she talks. She fortunately is retired, so she's not really harming anybody. But if she were working, I would probably give her some coaching to say, hey, the texts, the emails with the crazy caps, that's considered yelling. I will be honest, I did not realize that a bunch of emojis were sexual in nature for several years until this was brought to my attention a couple of years ago when I was preparing to do some sexual harassment training on emojis, and I was like, oh, I mean, there are a few of them. I was like, okay, banana, I get it, right? This little banana one, even on this slide. Okay, that one I kind of think, but there's like a whole slew of them that I just had no idea. And I'm not saying that you need to go and train everybody like, here's what this emoji means, and then do like, demonstration and everything. I don't think that's a great use of HR's time. But I do think just bringing the concept to the attention and equating it to when you're doing harassment training, all of you should be doing anti-harassment training. I think talking about texting, I think talking about Facebook, I think talking about IMs, I think talking about emojis and email etiquette is very important. And so in many ways, we need to update our sexual harassment training, and we need to update our policies a little bit to bring them into this modern world where people use these cellular devices and they text and they talk in pictures like cavemen versus and cavewomen versus like using words. And we looked at this, and I think a couple years back when I was doing that training, and I don't remember, it was like at the federal court level, there were like almost 15 to 20 cases of unlawful sexual harassment where the premise of the harassment was involved emojis. I think that number is going to continue to go up. So you can see people are doing this. I personally have dealt with a number of situations where, not like me personally, but for clients where this has occurred. It is a thing. If it hasn't happened for you, that's fantastic. But people use symbols, and like my mother, and like me before I learned about this stuff. Sometimes people need to be coached, and they need to be told, hey, the capitalization and the exclamation points, your coworkers are not liking that. Could you not send a picture of an eggplant? Like, I know you really like eggplant. It's not something that your coworkers are really liking here. It has a context, a sexual connotation. We want to take the confusion off the table. So if you could just not, use it. People need coaching, right? Emojis, a specific slide. There's all these little wrinkly faces. I don't know what most of these mean. I mean, I get a smile. I don't know what the difference is between like a normal smile and a smile with like your eyes closed. I'm not entirely sure. Some of these, we can guess, right? And I think that's part of the problem. Part of the problem is that an eggplant means something different to different people, and then it's going to be different in different contexts. These smiley faces as well, assuming that they're even legitimately being used and it's just not like a Miss Smiley insert or whatever it is, because of course employees say that all the time. There it is, 33 court opinions. Thank you. So 2017, 33 court opinions using emojis. So these symbols are open for interpretation, and that's part of the problem. When you use loaded, racist, or sexual language, we all get that. Like, we know that if you use a racist term, everybody, most everybody in the United States has come to appreciate that refers to racist intent. Same with sexual. I'm not going to sit here and like go on and on. I've crossed the line probably with my emoji talk already on sexual things. There are certain words that we just all know. If you say that, there's a sexual connotation, sexual harassment, sexual discrimination, whatever it is. We get it. Pictures? Not necessarily. If my mom sent me an emoji, I would not bet all the money that I have that she knows what that emoji means. Smiley faces? I don't even know what all these smiley faces mean. It's open for interpretation. The person on the receiving end, especially in a workplace context where that person feels like, hey, that person's a creep, or I don't like that person, they're going to be suspect when they get an emoji. They might read a little smiley face emoji, and they might read it entirely, like a coworker might read it entirely different from another coworker. And so the point is, this world is hard to understand. We are often going to be called in to investigate this, and we're going to have to try to get to the intent as an employee. an HR or risk manager, we're going to have to try to get to the intent. Are you intending to try to harass the person? And then you're going to have to talk about training and trying to train people on not to send emojis, to try to get away from that. Try to use language. At least we can kind of understand language, though, if you're from Minnesota, the whole passive aggressive thing, you never really know what people are intending when they say it. So anyway, this is why we just need to get rid of employees altogether. And then we don't have any of these problems. All the risk is taken right off the table. We wouldn't even need work comp insurance. Let's move on to wage issues. We've got a few minutes left here, especially from a work from home situation, but also just because people are tied to their cellular devices. So with non-exempt, what does the law say? The law says that you need to pay employees for all the, quote, time worked. We're not going to talk about salaried exempt employees, okay? So they get paid regardless. They could be working at, midnight on their phones. Great. They still get their salary as long as it meets all the criteria. We don't have to worry about extra compensation for them. But for non-exempt employees, what do we do when a non-exempt employee is dialing into the email and picking up emails at 8 o'clock at night while they're putting their kids to bed? Is that working time? Technically, yes. Now, on call time, we don't have to pay people for being on call per se, unless they actually have to work while on call. And work might be like a 10-minute phone call or a 15-minute phone call, a couple-minute phone call, or even a text back. We actually, federal law, we don't really have to pay them for that. A lot of employers do pay for that just because they don't want to run the risk, and they want to make sure that their employees are happy and like to be on call. But technically, you don't really have to pay employees for just a few minutes of time while they're on call, and you don't have to pay them for just being on call. If I'm putting my kids to bed and it's like 8 or 9 o'clock at night, and I'm a non-exempt employee, and I'm sitting there doing emails with my supervisor, that is going to be working time, and you're going to have to pay the person for that. So we want to make sure that, first of all, we want to take the risk off the table. We want to make sure that we're paying employees entirely. So one, we want to make sure that our training, our policies, our communications to employees, when they are working from their phones or from their computers outside normal working hours, that they understand that they should be clocking that time. Now, from a risk management standpoint, you might not want that to ever occur because you don't want there to be little overtime creep, right? Where suddenly it's like 0.5 hours of overtime on this employee, who is just sitting around eating Cheetos at their desk all day. But then suddenly they're working off, after hours. You might not want overtime creep. And so to do that, you might put in a policy, entirely legitimate, saying no work, absolutely not. You are going to be fired, disciplined, whatever. You're going to be fired if you work off the clock. Don't dial in. Don't, unless there's prior approval. Okay, you can absolutely have that policy. If the employee does it, say they try to bill you for half an hour of overtime, and they violated the policy, fire them. Sure, go ahead and fire them if you want, but pay them. You can't not pay them for the time that they worked, but can you fire them for the policy violation? Absolutely. A lot of companies don't allow non-exempt employees the opportunity to dial in to retrieve emails or to dial into the servers when remotely, either on their cell phones or remote when they're traveling, from a laptop or something, because of this issue. You might have a policy, it's entirely legitimate, of just saying, hey, non-exempt employees, you don't get to access your work email from your cell phone. How are you going to monitor it? Now, obviously, you could get your IT people, depending on the size of your company and sophistication, you could get your IT people to check their internet use and their login and all that. But for the most part, what a pain in the neck to try to track down, 6 minutes here and 10 minutes there and 15 minutes here from all of your employees. Better to sometimes just have a policy that says no accessing your emails outside the normal working day without prior approval, no direct little icon on your cell phone that picks up emails, And then also, from a good, and then also, consequences for violation of all of these. And then also just a really good policy. We want to, obviously, we have to keep, for non-exempt employees, we have to keep time records digitally or in person, but we definitely want to make sure that we have the employee affirmatively sign off that they have reported all of their hours. Again, that affirmative sign-off isn't going to be dispositive. That's the third time I've used that word today, and I'm going to try not to use it again for the next month. But it's not going to be dispositive on the issue of whether they are entitled to overtime or additional pay, because the Department of Labor might come in and say, no, they actually did work extra, even though the employee signed off on it. That the Department of Labor still might disagree with you. But it'll give us help. It helps us. It gives us evidence that the employee did work a set number of hours that they reported, hopefully not overtime. So the point is, with non-exempt employees, there are things that we might want to consider do we want to, and also when we have like a hands-free or no calling from the car for non-exempt employees, again, we don't want to be paying them necessarily. If they're getting a call after hours from a coworker and they're talking about work, and they're on the phone in their commute, how does that work? Now, commute time is not normally hours work time. It's not hours worked. And I shouldn't even say normally. It's not hours worked if it's commute time to and from work. It's not considered working time. But if a coworker calls another coworker and they start talking about TPS reports and getting that in, that creates a potential issue where it is working time. And also, how does that work with work comp? And then, of course, they're violating the hands-free policy that you're going to have. And then they get into a car accident. How is this all? We want to try to take this off the table as much as possible. So policies, communications, training on employees not engaging in these sorts of like outside working hours, as much as we can bring in their behavior to try to mitigate the risk. It's recommended and a good, just good practices and policies to have, though I'm sure it's not as fun as, employees would like. They probably would like to just do whatever they want and have fun and get in accidents and stuff like that. Okay, done. Next webinar, ABCs of Employment Law. Appreciate your time and attention today. Like I said, next month we're going to have a nice, this is Employment Law, ABCs of it. I always love doing those webinars. We're going to cover a ton with it. And if you have any questions, you're welcome to reach out to me or any other attorney at Thompson Co. I appreciate your time, and I look forward to next month's webinar.